May I please, your lordship? Item number 19, lordship. With the consent of other side, I beg to mention item number 19. This matter may come after 3 weeks, lordship.
Right, on the prayer for adjournment made by Ms. S. Kanungo. Learned counsel for the,
Sole respondent.
it is not objected to by the petitioner counsel. This is the matter of the TV.
Lordship.
Judy.
Deeply obliged.
Please, your lordship. Lordship, I beg to mention for listing of an IA lordship any date next week.
IA for what?
Suspension of sentence, lordship.
Criminal.
Lordship. Criminal. All right.
Yeah, please, your lordship. Lordship, I beg to mention item number 12 for adjournment, lordship.
Why do you want to adjourn?
Lordship, Mr. H.R. Sodri is newly engaged in this case, lordship.
You didn't engage.
Yes,
He's an old man. Okay, right. Adjournment prayer has been made on the ground that Mr. H.R.A. Chaudhary, the clinic counsel has been engaged for
Engaged
appellate,
appellant.
for the appellate. The claim not being objected by the learned APP with the matter after.
Any document.
Even this is after.
Lordship, 12 and 13 both are tagged.
Correct.
May I please, your lordship? I am paying for listing one criminal appeal matter
When?
on Thursday.
Thursday means
Five.
day after tomorrow. Day after tomorrow.
Yes, ma'am.
What did you want? Right, currently open did you? Thursday, Friday will be. Or. We'll do it next week,
Then after letter 13.
after 13th.
May I please, your lordship? I beg to mention for listing of two repetitions for tomorrow, my lord. Similar matter has been listed as item number 11 before the court number 1, my lord. Here, my lord, we have challenged an act of Assam fixation of selling of land holding eggs, my lord. Recently, the government of Assam has
Okay,
amended
similar matter.
similar matter. My lord. I'm obliged.
Please, your lordship. Lordship, I'm mentioning this matter on behalf of the Legal Aid Council, Dr. P. Agarwal. There's an urgency in this matter as the possession proceeding has been initiated against the petitioner. So, and his house may be vacated any moment now. So matter may be listed tomorrow.
Oh. Eviction matter. Will 5.
Yes.
Oh.
Deeply opposed.
May I please, your lordship? My lord, I have filed a writ appeal on 29th of January, lordship, and mentioned before the court number 1 on 30th of January. And order was passed for listing today, but a caveat was found. I tried my best to serve the copy of the caveat, but the learning council was not available, lordship. So I may be allowed to move tomorrow, lordship. Eviction matter.
Too many,
Eviction matter from the land and building. lordship.
DB1, they will be saying, what is the other bench doing? Putting all the cases before us. We listen on Monday. Monday you find.
Monday, lordship, 7th is
Caveat. If there's a caveat.
7th is fixed for eviction, lordship.
Monday. Will not be evicted.
Monday, the matter will become ineffective, my lord.
You mention it before the bench tomorrow. If you want. Maybe also.
Well, kindly down to page 39. Or with judgment, Malad, impugn judgment. Malad. Rule position is described by the. May I read the real rule position? As per paragraph 5.1 of Government of India Ministry of Defence letter that is showing so, the case of death of a armed force personnel under the circumstances mentioned in B and C, paragraph
Eight.
4,
39
there's 39 of the writ petition.
of the writ,
Malad.
of the writ appeal.
Writ petition, this is a writ petition, no?
39.
This is a judgment,
Rule petition.
it's a part of the impugn judgment, Malad. The rule petition is mentioned.
Yes.
Yesterday, finding of the learned tribunal as read out, Malad. This was, Malad, the rule position as this is the stand of the Malad union before the tribunal. It is incorporated here. My contention, this rule position specifically mentioned, Malad, how a person is entitled.
Let's see. Please read, where is it?
As per the paragraph 5.1 of the Government of India Ministry of Defence letter dated joint so, each case of death of the armed force personnel in the circumstances of category B and C of the paragraph 4, special family pension shall be continued to be admissible to the family of such personnel under the same condition as in force hitherto there shall be no condition of minimum service of the date for grant of social family pension. Relevant portion of the category B and C and paragraph 4 are reproduced here below. Category B, death and disability due to causes which are accepted as attributable or aggravated by military service as determined by the competent medical authority. This is contracted because of continued exposure to a hostile or work environment subject and to extreme weather condition or occupational hazard resulting in death of a disability would be example. Category C, death of disability due to accident in the performance of duty success. 1. Accident while traveling on duty in government vehicle or public or private transport. 2. Accident during air journey. 3. Mishap at sea while on duty. 4. Electrocution while on duty. 5. Accident during participation in organized sports event, adventure, activity, expenditure, training. 24 paragraph. As per para 104 of the pension regulation of the Army 2008, well, a special family pension may be granted to the next line of the service personnel if his death occurred in the circumstances mentioned at category B and C, regulation 82. This regulation due to hastened by the 1 injury disease, which was attributable to military service. B was due to aggravation by service of a one injury or disease while existed or arose during service, and in case of death after retiring and discharge, provided that the service personnel had retired discharge otherwise than the voluntary at on own request compassionate ground before the completion of the government. Well, my contention for losses, well, this position is described, the contention of our contention is incorporated in the impugn judgment. But while your losses yesterday we read out the finding of the learned tribunal, it was not even discussed about why this not taken into consideration this ground. Malad B and C category, admittedly, Malad, he is not eligible. And in fact, Malad, learned tribunal, while deciding giving the findings and giving the Malad relief, Malad did not take into consideration the medical board Malad findings. Malad. Supreme Court in repeatedly in case to case says that yes, judicial interference is, but the weightage is required to be given to the medical. This is a special medical board, mother. Finding is given by the medical board. My 2019, the SCC I have given. Paragraph 21, this is my copy. You'll also kind of look into.
Yes, one thing we want to know, when was he hospitalized?
My lord, he was on leave, my lord. I describe in my petition, my lord, he was
So
on,
according to you, he was on leave, so you don't know anything prior to his leave.
my lord,
Prior to the deceased being on leave,
my lord.
was he ever in hospital?
No, man.
Was there any medical report?
My,
with
my
regard
lord,
to-
my lord,
Sir?
the medical, my lord, our medical board has
No, we just
looked
asking
into every issue after my
the
lord,
council.
my lord,
We are asking some questions.
my lord,
When you want to give explanations, we'll give you time for that.
my lord.
You want some, just a bare fact you want to know. Now, prior to him taking leave,
My lord,
you all did not have any knowledge of his medical condition?
my lord, definitely at the entry level, he was not, my lord, there is no liver disease to him that admittedly. Subsequently, my lord,
So when did he take leave?
my lord, he was on leave with effect from my lord, 28 to 2018 to 34 2018.
28 to
18
2018.
to 34 2018.
34 2018. That means
Thereafter,
4 months.
my lord, thereafter, the leave was further extended for next 28 days with effect from 1/5/2018 to 28/5/2018
1/5/18 to
to 28/5/2018.
28/5/18. Then
He died on 16/5/2018.
16/5/2018. So he died within 2.5 months
My
of
lord,
him taking leave.
my lord,
Now, prior to 2.5 months of taking leave, what was his medical condition? He had no fatty liver. According
lord.
to you,
my lord,
you did not know. You do not know, correct?
my lord,
You do not know whether he was drinking alcohol.
my lord,
And in 2.5 months, he drank himself so much, he got liver cirrhosis and he died.
admittedly, my lord, definitely he started,
How, from where?
that is why he took
He's-
him most probably.
Where do you say? No, most probably will not come. You've got to go by facts.
My lord, a person was on leave, my lord. He went to medical, my lord, he himself admitted to the medical, my lord.
Correct? Correct.
Meaning thereby it is not after the leave the things were developed. It is definitely started earlier.
We don't know.
My lord, the medical expert, my lord,
Counsel.
my lord,
It may have started earlier. Fatty liver may have started earlier.
Malo.
But do you know that fatty liver is not caused by alcohol alone?
my lord,
There are people who do not drink alcohol,
Malo.
but who still have fatty liver.
my lord.
You can ask your friends among the lawyers also, some of them who do not
My lord,
drink.
admittedly, my lord, it is developed due to.
So how do you say that his fatty liver is due to alcohol?
we are not saying that. It's a multi-organ failure finally. That is the,
When a person dies, it is multi-organ failure all the time. It is a, you see, whenever there is, you see, when there's a heart attack,
Malo,
when there's a liver failure,
Malo,
you see, what happens is the body shuts down one by one.
Malo,
At the end of the day, what happens is it is a multi-organ failure.
Malo.
It is not that if your heart pumps,
Malo.
heart failure, then the liver and everything will keep on working. It all fails. When once the liver fails, then
Malo.
it will then the kidneys will fail. This will fail. At the end, heart will fail. It's a multi-organ failure. Means is the end result of the initial the failure of one system.
Malo.
So multi-organ failure is a multi-organ failure. The issue is they are saying it was due to liver cirrhosis. They are saying it is by alcohol.
Malo.
From where do you get that alcohol? He was on leave for 2.5 months
Malo.
and he died during leave.
Malo.
Now, prior to his taking leave, there is no whisper that he was an alcoholic, that he used to drink alcohol, that he had liver cirrhosis. Within 2.5 months, he had everything. How is it possible?
Hmm? In fact, Malad, on the basis of this, Malad, the medical board was constituted. Accordingly, it's verified. My contention before law says, Malad, we are laymen, Malad. The medical doctors, they are the expertise on the field, Malad. There's a board of medical was constituted,
Doctor's report is only advisory in nature.
Malad,
We don't have to accept.
Malad.
You see, because first of all, when you are going to when you are going to say that it is alcoholic fatty liver, you've got to show where is the how did they come to that finding? Was there any blood sample taken? Was his blood tested for alcohol? How do you differentiate fatty liver which is caused by alcohol and that which is not caused by alcohol, that which is caused by oily food? How do you differentiate? Is it written mitha tel out here on alcohol? Not written. How will they know?
I'll produce the medical record for your losses, Malad, in that effect, Malad.
No, how will that help?
No, definitely help. The expertise doctor, they are given some finding on basis of the verification of the, Malad, definitely there must be some mention, Malad.
Those medical reports were not placed before the single bench.
No, I was not there in the tribunal, Malad.
You see,
Malad,
they're not.
since your losses raised the question, I would like to place the medical report record before your losses to satisfy your losses for it, Malad.
Come to page 28, para 28, page 41.
Malad, Malad, Malad.
Please read.
The perusal of the case shows that the disease Nayak so-and-so had proceeded 62 days annual leave on so-and-so to so-and-so, condition deteriorated on 4/5/2018. He was admitted to so-and-so hospital, ultimately breathed his last on 16/5/2019. Court of inquiry was conducted by the commanding officer, record officer of so-and-so issued a certificate regarding Nayak H. Philip that his death was found due to multi-organ failure following a cirrhosis liver in Asia is not attributable to the military service. This statement of medical officer was placed on record at page 27, in which it was mentioned that they, as individual died as a consequences of complication of the alcohol-related disease, which is neither attributable by the military service.
So this statement is already there.
Malo.
Then
That means my contention if your law says, Malo, the medical report will be reveal everything because they diagnose the person and come to a conclusion.
now you
Given its opinion that it was due to that alcoholic related illness.
come to para 29.
From the document in which are placed on record, it appears that the husband of the applicant had suffered from the cirrhosis liver, which had ultimately resulted in multi-organ failure. It is mentioned that this disease was alcoholic. However, the learned counsel for the applicant has pointed out that disease was never issued any reprimanded or red ink entry and black ink entry for alcoholism. That is the contention of the learned
No,
counsel for the applicant.
you see, there was never an issue of alcoholism with her. There was never an issue of him drinking.
No.
So how do you suddenly say that it is due to alcohol related?
I am not saying suddenly, Malo. It's an expertise, Malo, opinion. That is why that two judgment I would like to place before losses.
Yes, 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 yes.
That is your losses 2019 9 SCC 667. Para Malot. Para Malot 21. And 2022 SCC Online Supreme Court 897. Para 25. 892.
I mean, there is no viral medical, the certificate given by a medical expert is not conclusive.
Malo.
In your case, there is nothing to show that the person had an history of alcoholism. That is what we are asking you.
That is why I would like to place the record relevant medical record to satisfy your losses query, because we are Malad going through that file, Malad, the contention also read out just now, Malad, before tribunal. But medical expertise, opinions given by the doctors, their expertise in field. Yeah, yes, judicial interference is Malad, as per Supreme Court judgment, this says that it should be given weightage because they are expertise in the field, Malad.
Not determined by the computer. Buying a family to ice and something. It is contracted because of the party to ice and it's not aggravated. Aggravated by
My humble prayer for your losses, at this stage, notice of mission may be issued, my lord. Let the person be before your losses and finally dispose of the matter, my lord.
Aggravation by medical service of a wound injury or disease which is listed before or around during. Which is a disease before. Aggravated by medical service.
So Swami, where do we find that opinion of the medical, doctor, that statement at page 27 of the record, which is reflected in para 28 of the judgment?
There is no evidence for any other service related fact. They are consciously not mentioning the word disease. Mr. Goswami, is liver cirrhosis a disease? Is it a disease?
It is a ailment, my lord.
It's an ailment.
Pursuant to who is subsequently he succumbed. My lord, illness is,
Ailment and disease different.
my lord, regarding disease, my lord.
What will be a disease? Will cholera be a disease?
Definitely,
Huh?
that will be a disease, my lord.
Tuberculosis is a disease.
My lord. Cancer is a disease, my lord.
Cancer is a disease. Liver cirrhosis is not a disease.
I have no idea, definitely maybe a disease, my lord.
Just give me the dictionary.
It's a lifestyle disease, my lord. I would like to say, my lord.
So it is a disease, whether it's lifestyle or not non-lifestyle. It's a disease. You're right. Third, Mr. UK Costa, then CGC. So submit that. The learned tribunal heard in granting special family pension to the respondent number one, to the respondent on account of the death of her husband, died of liver cirrhosis induced by, who died due to multi-organ failure caused by liver cirrhosis, on account of drinking alcohol. You submit that the sitting of the learned tribunal that there was no material on record to show that the disability was a lifestyle disease due to excessive intake of alcohol by the deceased was found. If you notice, returnable in COVID, the failure to take steps on the respondent by speed post within 2 days. This is the matter. Give a date.
But, well, interim malot,
Huh?
I have interim prayer malot. In the meantime, malot,
No, the interim prayer may be considered on the next week. In the meantime, on the next day, medical records of the deceased should be brought by the land city.
Lordship,
Yes,
Lordship, this case was substantially heard by, on 6th of January, Lordship, when during the course of deliberation, certain questions were raised, on for which I was supposed to receive instruction, Lordship. That instruction is waited, Lordship. I prefer for 10 days time, Lordship.
correct. So this is before the same bench. I mean, DB1, no?
Lordship.
Right. Mr. B. Chakravarti, then counsel for the petitioners submits that the matter had been heard at length by DB1 and
17.
the case had been adjourned to enable him to obtain inspection.
10 days time.
Fixed it.
Huh?
It is some emergency is there.
They are called, they feel that the matter may be listed before DB1. List the matter on
17th of February. Of last year.
Your loss, item 26 was also there. Item number 3.
Well,
Yesterday,
3 has come for admission, 26 is for orders, Lordship. In both the cases, my
pleadings are completed, man.
objections have been filed. May I pray that it be taken up on 10th, subject to my
10th of this month.
convenience, Lordship.
What?
Because both the cases arises out of the same hour.
Did you want to do it today?
Lordship, I have got some difficulty. I have to take some instructions, Lordship.
10th of this month.
Okay.
I have taken the consent of my friend who is appearing in the other.
Right. Mr. R.P.D. Chaudhary, the learned standing counsel for the NI. Ms. N.J. Datta. For the petitioner in Criminal Appeal 460 of 2024. Pray that the matter may be listed on ten. List the matter on ten. Then on the next, in item 20.
Six.
Same, except instead of Mr. NJ Datta, it will be Mr. S. Borbahan. Same.
Oblige.
Correct. Third,
J.I. Barbu.
J.I. Borboya, Learned Counsel for the Appellant.
Appellants.
And Mr. R. Kaushik, Learned Additional CP. Appearing for the CP. The appellant has been for bail. And for setting aside the impugned orders dated 14/11/25 and 3/1/2026 passed by the special judge Charadev in Sharari PS case number 96/25 registered under sections 152/318 of the BNS Act, 2023, read with sections 17/18/39/40 of the UA P Act 1967. By the case of the petitioner is that, a case of the appellant is that they were arrested on 11/10/2025 on the ground of illegal interstate importation of areca nuts on the basis of fabricated tax invoice. The further charge made on the, no, the reason for adding charges under the UAP Act 1967 on the appellant was on the ground that the proceeds of the sale of the areca nuts were being channelized into the terrorist organization such as
NSCN.
NSCN and
Alpha I. I.
Packet I. Charge sheet has been filed or not? No.
No.
Next time. This court had. No, no, Mr. J.I. Barboya submitted that during the filing of this petition, the petitioners are also, the appellants are also entitled default bail under section 167C. No, it will be, what will be the new?
40.
No, CRPC.
CRPC 167.
16.
The
Yes,
equivalent.
I'll giving. BNS হয়ে গেল না 167 BNS হয়ে গেল
BNSS, BNSS.
yes my lord I'm giving my lord lordship can
Okay. So then, a default bail under section transfer of the BNS. Keeping in view the fact that more than 9 days have elapsed from the date of the appellants being sent to judicial custody without filing tax.
187.
Huh?
187.
Further, no applications for extension of time for filing charge sheet beyond 90 days has been applied for by the state. And as such, no order was said to have been made by the learned court for extending the time for submitting the charge sheet beyond 90 days. Next, Mr. R. Kaushik, learned APP, had been given time
187
on 2/2/26 to verify the said issue. He submits today that
On telephone instruction.
whatever he submits today, that as per instructions received by him, no charge sheet has been filed by the state till date. in connection with. What is that police case number?
Solari PS 96, my lord.
Sonari PS case number
96/25.
96 of 2025. And neither has any application for extension of time for filing charge sheet beyond 90 days been made by the state. In view of the above fact, it is clear that the applicants are entitled to be released on default bail in terms of section 189, 187. Or I have to get used to this.
That's it.
187 of the BNS. Accordingly, in the event of arrest,
They already.
accordingly, accordingly, the appearance are to be released on bail, on default bail, on furnishing a bond of rupees 1 lakh each. No, you'll have got number. Arika nuts, they're millionaires. You see what happened in Mizoram, I'll tell you. In Mizoram, this Arika nut route, that is the main
Yes.
route. So they were getting caught left, right, and center. Even by the police and even by the villagers, because the villagers' livelihood was great.
Yes.
Their local Arika nuts could not, they're not finding a market because of these Indonesian, Malaysian Arika nuts. So that, since that route was now, that route could not be used, what these smugglers did, apparently, allegedly, they built a new road in the forest.
In the forest.
Big 12 wheel trucks going through. That's what we heard. Apparently, I'm not saying it with 100% certainty. Have to be careful also.
And they got,
So that's why they have got money.
even this got damaged, my lord.
Huh?
Even if this product got damaged, my lord, because I have seen a lot of cases, my lord. These damaged products are more valuable because these are used in paint industry.
No. Huh?
Paint industry.
Paint industry.
Paint industry.
No, they are not damaged. You go to various states, Gujarat and all your supari, all those tin wala ka supari. These are all rotten suparis which cannot be sold in the market. So that quality one, they go there and then they mix it tobacco, then they sold as mitha supari. Anyway, well, 1 lakh each with one surety of like amount to the satisfaction of the learned CJM,
Not special judge.
Special.
special judge,
Saraido.
Huh?
Saraido.
special judge NIA,
No, madam.
No.
Special just.
special judge Charadi.
Saraido.
That's all.
Hmm.
Consequently, the impugn orders dated are hereby set aside.
Plus.
Pass this Fanari case. I think conditions of bail are already provided in the form. No?
Yes, it is there, madam.
Huh? Dispose of.
Wait, please, your lordships, in terms of the last order dated 27/1/26, the medical reports of the two police personnel were part of the team attacked by the accused who escaped from the boat.
No, so what is the requirement of that? What is the issue here? This person has apparently jumped into the river. His body is not found. And neither do we know whether he is alive, dead or alive. Correct? Now, by this petition, what do you want?
Actually, by our prayer is, my lord, since the petitioner is disappeared from the police custody, since July 2023 to till date, my lord. So, we are
July,
sure that he is no more, my lord.
huh?
We are sure that he is no more. So in that respect, we are seeking some compensation from the state. Since,
Did the police kill him?
my lord,
Did the police kill him?
yes, my lord, as according to our submission,
According to your side, what is the proof that the police
Lord.
killed him?
since from the police custody, he is disappeared since long days,
It said that he jumped into the river.
my lord. On that aspect, my lord, we are explaining our pleadings, my lord.
And he's
Whether logically is it possible or not?
and how many cases of dacoity has he got?
My lord, that is true.
How many?
So-
How many?
My lord, that is true numbers of cases against him. I think 12, 12 or 14, I think total.
14.
14, I think.
40.
My
40 dacoity.
My lord.
Huh? He has cases.
My lord, in the different states, including Northeast, my lord.
Now it's the case of the criminal wanting offensive.
12 cases, along with present case, 13 cases, my lord. Well, that is true. The allegation against his is numbers of allegation, my lord. But we are trying to submit by this case, my lord. Whatever may be, my lord. A person disappeared from the police custody and it's amounts to extrajudicial killing, my lord.
No. Doesn't amount. Where does it amount?
My lord.
There's no. Where does it amount to the extrajudicial proof? Where?
The personnel were attacked, my lord, on the boat, but
Huh?
the personnel, the
Ah.
police personnel were attacked on the boat by this criminal.
My lord. On that issue, we are explained here whether it is logically
The medical
possible or not.
reports. About that, find it.
Huh?
Whether it is logically possible or not.
Why not? Very
A
much.
person with handcuffs surrounded by 3-4 police officer, and he kindly see the my lord.
When you have got,
Next to it, one photograph.
when you are involved in 13 dacoity cases all over the state, you are liable to do anything.
Kindly see my lord, page 53 of my petition, my lord.
And I think not only dacoity, you have got some other cases also. In.
Page 53, my lord.
You are a threat to society.
This is the condition of the petitioner at that time while he was in police custody. He was seriously assaulted, seriously injured. And in this situation, it is whether logically possible or not that a person with handcuffs surrounded by 3-4 police officer in a boat.
Is it logical? Is it normal for a person to have around 13 criminal cases against on different cases? Huh?
That is true, my lord. That is, I am not denying.
If it is not logical,
against
why
him,
is it not logical here?
my lord? But I am saying only on that point that my lord, a person may be guilty or he may be punished in accordance with law, my lord. If he proves his guilty, my lord. On that point, my lord, I am submitting. He may be punished in accordance with law, my lord. Whether life, whether death, whether any other. But from police custody, he disappeared since long back, till date.
Who's the just person who jumped? Manohar Hussain.
Manwar Hussain.
My lord, the magisterial inquiry report is with me, my lord, if I may be permitted to read out. May I read it out? On the incident, my lord, on 9/7/24 at about 10 p.m., Juhi Konkon Padgiri, WSIP, was informed by the OC Sumit Mahato about abduction of a couple from Jalukbari in a blue Swift Desire bearing registration number so and so. Accordingly, police team headed by Juhi Konkon Padgiri proceeded towards Bezara Sok. The vehicle dashed the police vehicle, and accordingly, OC Sumit Mahato and UBC Mrinmoy Shaloy got injured. Following, a case was registered at Baihata Sariali police station regarding attempt to murder by PS case number 182 of 24 under section 61 to 140 109 132 74 111 BNS, and Premankur Hazarika, inspector, was entrusted to complete the investigation. Later, Singorapara Gaon Pradhan Srimati Pompi Boisho informed over the telephone to WSI Juhi Konkon Padgiri that they found one couple near her house. The said couple was rescued by the police patrolling staff. Upon examining it, it was found that they were kidnapped, molested, and physically assaulted by the culprits. Moreover, their cell phones were taken by the culprits. Information along with the phone number of the victims was shared by Juhin Konkon Padgiri to the officer in charge, Sumit Mahato. Following day, the location of the rescued couple's mobile number was traced at Boragaon, Guwahati. Accordingly, police team headed by SDPO Rongia, OC Kamalpur, CI Baihata, WSI Juhi Konkon Padgiri, other police staff proceeded towards the location. During police operation, 5 persons were found in the car. 1 person ran away. Other 4 persons, namely Tohizuddin, Johirul Islam, Ramjan Ali, Manwar Hussain, were brought to SSP office, Amingarh. Accordingly, interrogation took place. Culprits admitted their crime, that they kidnapped the couple, and at night they had dropped the couple at Baihata Sariali. Upon search operation, the following seizure lists were obtained by the police officials. Maruti Swift Desire car bearing registration number so-and-so, 3 smartphones, 2 rods, 2 daggers. Persons who were injured by the fleeing vehicle, OC Sumit Mahato and UBC Mrinmoy Saloy. Details of the accused persons, well, these 4 accused persons, including the husband of the petitioner. During interrogation, Manwar Hussain revealed that he had kept a pistol at Kolasar, that is his home, and he could show the place. Accordingly, on 10/7/24, a police team headed by SDPO Rongia, IO Premankur Hazarika, OC Soiga Pires, so-and-so, was informed, including the Debanon Medhi, the Lance Naik Debanon Medhi who was attacked, was formed for police investigation. On their way in the river Brahmaputra after Bamundi Sor, the said accused person attacked Lance Naik Debananda Medhi on his left-hand forearm and SI Dinesh Sutia on his head and chest, and jumped into the river with handcuff. And that is the tribunal's conduct. This is the magisterial inquiry report.
Is it part of the physical inquiry report? Where is it? Is it part of the record?
Madam, I may be permitted to play this, madam. I have the original. with me. Well, it's part of the record. I'm told by my learned colleague. Page.
No, this is not brought on by affidavit, just.
Original. Part of the record means, have you submitted it? Sure.
Affidavit, yes.
Affidavit করে দিছে। Affidavit করা না। My lord, I'll place that if need be. Please give. Please. No, আমি affidavit করে তো দি দিয়া নাই। কোর্টে হেড কথাই কইছি। Boy.
I think we have got the photo.
Yes. The petitioner's husband is a hardened criminal, my lord, before your lordships,
He is innocent.
until he's proven guilty, my lord. And he prevents that by hitting them on the boat. My lord, I have the medical reports. That's when he jumps. He's a threat to society, my lord.
Report. Okay, in the very common memory. There's nothing. You pass on it. All right, Mr.
Malad, I'd like to submit one thing more subject to lordship permission, Malad.
Yeah.
Malad, kindly peruse page 44, forwarding report of the, Malad, present FIR,
Hey,
page 44, Malad.
yeah,
Bottom paragraph, Malad.
yeah.
It is pertinent to say that the house of the accused person, Monwar Hussain, alias Babul Ali, son of Kubbas Ali, alias Norsad, village so-and-so, was at Kalasar and as part of investigation of this case on 10/7/24 at around 2:50 p.m. A team led by SDPO Rongia, myself, CI, Baihata, OC Saigaon Police Station, OC Swalguchi River Police Station, etc. were taking him to his house located at number 2 Kalasar for house search, recovery of incriminating materials within bracket pistol. Since he was involved in a number of dacoity and robbery cases, while he was being so taken at around 3:50 p.m. in the middle of Brahmaputra river, after crossing Bamundi shore, the accused suddenly attacked LNK 581 Devanand Medhi and SIP Dinesh Sutia respectively, and injured both of them by beating them and jumped into the river to escape. Since the river was footing, he was
Fighting them.
swept away. The SDRF was immediately informed, but till the time of submitting FIR, no trace of the accused has been found, my lord. I want to submit here, my lord. After he jumping, immediately call the SDRF, my lord. SDRF searching him, my lord. But SDRF also became failed to trace out him. Now, my lord, another question I would like to raise here. His house located at Kalasar, and Well Road to go to his house from my lord by road Mokalmo town, my lord, via Haju, Kolitakusi road. But suddenly he has to taken away by river to Kalasar, my lord, by police. So on that aspect, we have also some doubt why he has taken by river instead of by road, my lord. So while easy road is by road is easy than river road, my lord. Now, my lord, at last, my humble submission before this honorable court, my lord. I also admitted here against him, so many allegations is there, number of cases registered against him, Lord. But for the inch of justice, he may be punished in accordance with law as prescribed by the law, my lord, whether death, life, etc., my lord. But since he is disappeared from the police custody, my lord, I am respectfully submitting before this honorable court, it amounts to extrajudicial killing, and for the inch of justice, where for his dependents like minor children and wife, some compensation we are seeking for this honorable court. And on another point, I would like to submit, my lord, present ministerial inquiry report. Copy of this report were not furnished to. They are not furnished to us, my lord. And that's why we are unable to go through the ministerial inquiry report, my lord.
We'll give it to you, but we are closing this. Your prayer has been answered. Report has been made. We'll give it to you. Whether you want to challenge it, that's a different thing. You give him a copy of the ministry. You have read the cost of it.
Lordship.
Yeah.
Make it available.
At the time of his jumping, he was seriously physically injured, my lord. He logically it was not
How do
possible.
you know? You were with him?
My lord, photograph is there. Photograph is there.
Another
His injury
contention
photograph.
raised by him, my learned friend, is he should have been taken by road. Well, why not road? I ask myself, by aircraft. That would be the fastest.
We don't know. The thing is that you see, just as you are innocent, till proven guilty, how can we say that the police are guilty unless proven guilty? Well, shouldn't the law apply to them also equally? Or for criminals, for persons accused as criminals, for them the law should be more relaxed. Is it?
But
Apply equally.
in respect of his,
Apply equally.
in respect of his disappearance, my lord.
Huh?
In respect of his disappearance, my lord, till then. So
Escape, my lord.
if
It is you wanted a magisterial inquiry. That's your prayer in the writ petition. Magisterial inquiry has been done.
Well,
Report has been made. End of the matter.
You have any grievance, you take it up in an appropriate. Yes.
But that now that magisterial inquiry is there. Report is there. We'll furnish it to you. Direct, we'll give it to him.
I will.
Heard, Mr. Yes, Mr.
that may be kept open, my lord, you can further approach for appropriate.
That is there.
We are not saying anything. That is totally up to you.
My lord. AK Azad.
AK Azad, learned counsel for the petition. Also heard Ms. Sharma, learned
Government advocate.
government advocate for the state. Responded. Anybody else? That's all. Yeah. Hearing concluded, order is up. Or did we dispose it off? We were basically discussing. No, we disposed. No.
Deeply obliged.
Basically discuss.
Man.
May I have a copy of the
We'll return the original to you.
obliged lordships?
Yes, original. Yes, okay.
Item of 5, my lord, service is not funded, my lord. I filed one IA for my lord for paper publication, my lord. The ISOL method. IA is my lord.
Your case is that 28 and 34
Yes, my lord.
be given together.
2088.
Hmm?
This is IM, my lord. 2088. There's a,
What happened out here?
my lord, I have taken step by register.
Huh?
I have taken step by register post, my lord, and there's a direction for Dusty also, my lord. So I could not take Dusty, my lord, because they're not aware of this.
The order, there's no order.
In my lord, main appeal order is there.
Here the period is 115.
Yes, ma'am. Twenty-six, 5 to 2024.
20,
26, 5 to 2005.
25.
26 to 2005. Yes, ma'am. Let the notice be issued remaining respondent by register with AD as well as the for Dusty.
So there is no return of any.
Some unsubs, my lord, there's office dot, my lord. Unsub and my lord, sub, my lord, is.
R4 has returned answer with
Yes.
personal remark not known. No AD from 3, 5 to 8.
So I filed the IF file for paper.
What is appearing for 3, 5 to 8?
No, nobody, man.
No further. Why didn't you mention this issue on 4/12/2020?
My lord, earlier I mentioned, my lord, but.
Bench hunting.
My lord, no, my lord. Honorable Chief Justice, it may remain as it is, but today it come for orders, my lord. So, my lord, this, because of this, these orders, my lord, so if, unless it is complete, my lord, this, then no.
Yes, Mr. Malhotra.
Your Worship, I'm appearing in item 8.
8 is a retail, my lord.
In item 8,
Sir?
the learned counsel for the writ appellants were directed to obtain instructions. And on the last occasion also, they had taken some time.
With
to
regard to
obtain-
My lord, this, my lord, the 34 and 28, 34, in some cases, as per my lord, the client of the Malhotra, my lord. This
they have been given,
Yes, my lord.
been given both.
Yes, my lord. So then that instruction, my lord. So, my lord, before this honorable court, this court, my lord, it will be better case, my lord. So not when hunting.
I don't know, I'm just,
The chief is aware of, my lord.
I'm aware of this case.
Yes, ma'am.
I thought, oh, good disposal rate today.
But this I have to mention, they mentioned, they indicate this thing, my lord.
If the issue is small,
Yes, my lord, this is small.
the issue is basically whether 28 can be given along with 34 simultaneously. That's
Yes.
all. According to you, it's either one or the other. Cannot be both.
In a given facts and circumstances, it can be.
Can be.
In present facts and circumstances, it cannot.
Okay, but what about all the cases? Aren't they on the similar footing?
My lord,
But
is-
that has been wrongly given, my lord. The railway is taking action for the recovery. I have received instruction, my lord.
Anyway, no,
And there is an audit, my lord.
no, if we are going to hear it, then I'll do it. Otherwise, no point hearing.
Because I am ready, my lord. for it.
So you all want to do it or you don't want to do it?
my lord, no, it is better to do it, my lord, because otherwise, my lord, without hearing, my lord, it will be difficult, my lord. It is filed, my lord, earlier, my lord, so some short date, my lord, within 7 days, I will take paper publication, my lord. And two daily, my lord. Immediately, my lord, this matter will be hard, my lord. It's a very small issue in one case, my friend, this case, my lord, this senior friend case, my lord, this is only 34, my lord. It was, my lord, initial when award was in as per section 11, we paid them. Thereafter, my lord, it was a reference code denied and award is passed under 26, my lord. Then, my lord, this they filed 26 award is the, my lord, 26 award, my lord. So far, award is concerned, my lord. And thereafter
Reference is 18.
reference is 18, my lord. The award is 26, my lord. Award passed, my lord. Initial award is 11, my lord.
Ah,
You know, reference code
what
number
is
is
11?
6, my lord. And therefore, they, in this case, my lord, there is execution case, my lord, it was open for them to claim the 34 interest, my lord. And that was, my lord, there was this district collector was an order to pay the amount from the date of possession, my lord, which was already paid by us, my lord.
Under 28.
34, my lord.
34 already paid.
Yes, well, and so far my friend Nair case, my lord, both 28 and 34 was paid by the High Court, my lord. High Court. That cannot be, my lord. That is also from initially we paid the amount, my lord, the initial award, my lord. So that award is paid, my lord, but in spite of that, my lord, award of that
You paid it in time.
yes, my lord. That is case, my lord. So entire cases, my lord, 28 and 34.
So they're slightly different facts.
Yes, my lord, but the cases, my lord, my friend Gupta's case, my lord, these cases, my lord, we have paid 28 and 34 paid, then they again claim 28, my lord. So then only this, intention of legislation, my lord, the same, the 9% per annum, 15% per annum. So that may be in one, my lord. Either 28 or 34. But if it is not paid in time, my lord, then 34 will also come and 28 also come. This is the problem.
So if it is in time, then it's 34.
If it is it was award was passed, my lord, it's immediately taking possession. Then 34 will not come, my lord. Because I've gone through one judgment, my lord. Yes, says the compensation, my lord, is only for deprivation of the utilization of money, my lord. Statutory amount, my lord. So because that amount is supposed to 3 years back, it was given.
Anyway, no point.
Yes, madam.
Yes, what to do? We'll adjourn the matter.
So far as item number 6 is concerned, my lord, perhaps that can be disposed of. Subject to a very, because we are on a very initial.
The problem is this will have a bearing on the other people.
No, my lord, as far as item number 6 is concerned, the point is that they proffered a civil division, 227 petition, and consequently this writ appeal has been filed. So issue raised by us was that after a disposal of 227 application, writ appeal will not lie. So that is one of the points are, pending consideration in item number 6, which is writ appeal. Just a minute, let me complete. Which is item number 6, writ appeal 265. Now, apart from the answers on the merit, on the other hand, the Honorable Court asked us to exchange the written notes of argument that we have done. And we have filed also the judgments that to be relied on us by in support of that case. So the point is, if your lordship decides that notwithstanding the disposal on 237 writ appeal will lie, then perhaps the question of entering into the merit will arise. But the point is settled by the Honorable Supreme Court in number of these decisions, my lord. My lord, this submission was made by the other court also, my lord. My lord, what happened, my lord? There's 2 petitions there, my lord.
Gupta for instruction.
My lord,
See, one thing is that you have already made submissions before
yes,
the DB1.
Yes, ma'am.
You have submitted your arguments.
Yes, ma'am.
Arguments. I don't think it would be proper for us to.
So matter has not been that way marked as part heard. So therefore, your lordship can also like to take it up, subject to your lordship's convenience, of course, my lord. But because I am pointing out only because of the reason is that point is very small.
Appears prima facie appears that 226 will not.
No,
been applied.
Because court number 1, my lord, this is one to hear because there is one, my lord, I filed one writ petition.
Okay, you all hear it before that he wants to hear this.
Yes.
Don't
I filed one writ petition and one CRP, my lord. Both was, my lord, or judgment was, my lord, same.
He doesn't want. He wants.
No, my lord, no, that is wrong, my lord. That is wrong, my lord.
For some reason or the other, my lord, I do not know why all these matters have been tagged together. Although, my lord, there are slight differences in facts. All cases are not on identical footing.
In my senior friend case, I filed one writ petition, and another CRP. But it was clubbed together, and the order was.
Yes, IA Civil 2322 of 2024. Arising out of WCT 115 of 2024.
If I may submit your worship.
Yes.
In item 8, if my learned friend has received instructions he may kindly furnish a copy of the instructions to us. Because on the last court date, he was directed to obtain instructions regarding the present writ appeal.
How will you find it? Put it again. on the screen.
WhatsApp.
Show it to him.
WhatsApp, my lord.
He'll send it to you by WhatsApp.
Yes, Your Worship.
Please, you will send it. Yeah, right. So in that case, right, in terms of the order dated 26/5/25, notice was to be served upon the respondents number 3 to 8 by registered post with AD as well as dusty service. The next para, the office note dated 19/8/25 states that notice in respect of respondent number 4 has returned unserved with postal remark, inverted commas, not known. In respect of respondents number 3, 5 to 8, there has been no return of unserved notice or AD card. Till date. Further, no affidavit regarding service of notice by way of dusty service has been submitted.
I mentioned I am, my lord. I could not take, my lord, because of money.
Has been submitted by the appellant, applicant, appellant. Next para. Mr. Estimated CGC submits that he has not been able to serve notice by way of dusty service on the respondent's number 3 to 8. And he now prays that instead of serving notice by way of dusty service, he may be allowed to make newspaper publication of the note.
Yes.
Where?
My lord, Aizal, my lord, one in the English Daily, my lord, and one vernacular, my lord. Aizal Post, my lord.
Let us see the address.
One Bhairavi also there.
All Kalasip district,
Yes, man.
all of them.
Yes, man.
And they are all Bhairavi.
Yes, widely circular.
Bhairavi is a village.
I know.
Even think newspapers will be there.
Because Dusty also, my lord, now we are not familiar, my lord, familiar that said area, my lord.
No newspapers will reach there. Bhairavi not. Unless you go and give newspapers to the villagers there, it will not be.
But, I can inform the concerned advocate, my lord, they
No.
concerned
You have
advocate.
to serve notice by the people.
Dusty, my lord, not possible because
You go there. There's no point asking you to do something which will have no effect. When newspapers don't go there. You know Lengpui Airport.
I know.
Lengpui Airport newspapers don't reach Lengpui Airport also. What about you talk about Bhairavi North?
I'll try now. Also, my lord,
Ah. Okay.
my lord, newspaper as well as my Dusty, my lord. I'll try now.
On considering the fact that this court by order dated 26/5/25 had only directed the appellant to serve notice by way of dusty service. And keeping in view the fact that newspapers hardly reach villages in Mizoram. Especially Bhairavi North. I know because I go fishing that. I used to go fishing that long time back, 25 years back.
I have visited my lord, this place, my lord, twice.
And you got to go by boat.
Now it is developed, my lord. I have twice visited, my lord.
You see, there's Bhairavi North, there are different. Bhairavi, you get the railway station.
Yes, my lord, the railway station.
And it doesn't stop. The present rail doesn't stop there. That's only for goods. Not for. What do I say? especially Bhairavi North. The appellant would have to serve notice upon the respondents number 3 to 8. 3, 5 to 8 by way of justice service. Within a period of
2 weeks time again.
2 weeks. List the matter on the date.
My lord, the other items are also, if your lordship keeping it tagged.
In the other item, with this text, in item 8,
Item 6, lordship, I mean 6.
just a minute. Item 8, in WPC 383-325, Mr. H. Gupta submits that he will send a copy of the instructions, additional instructions.
Yes.
To Mr. A.R. Malhotra, learned counsel for the respondent by way of WhatsApp during the course of the day. Then in item number 6, Mr. S. Datta.
Yes, my lord. In item number 6, if your lordship is fixing up some other day or keeping it tagged with this.
25th.
Well, instead of 25th, can it be on 26th?
Okay, that earlier also make it 26th. Huh? On the prayer of Mr. S. Datta, and Senior Counsel in WPC 265-2023, says that the matter may be listed on 26th. This is the matter 20.
Item 8. Item 8 also, Your Worship, 26th.
Everything will be 20. No point doing part. Oh, we're ready.
We are always comfortable in this court, man.
Okay, we'll take up that item 6 then.
He picks up the sentences selectively.
Huh?
He picks up the sentences selectively, depending on time.
Correct. Correct. He is very good at it.
Highly obliged.
I'm obliged, yeah.
May I please, Your Honor? So, Lordship, in regards to here, Thailand pay fine of rupees 10,000. So possibly, my lord, there is no intention possibly, my lord, because considering the injuries, my lord, confusion and all these things, and his defense in 313 is that she failed out.
There is no eyewitness, but
No.
there is an extrajudicial confession.
My lord, true. But
Then that and the two and that couple also have seen the trouble that you caused the night before.
no, true, my lord. But so far as PW4 is concerned, my lord, she admitted that she never made a statement before police during investigation period. And whatever she stated before the court, my lord, she has said it for the first time, my lord. So possibly, my lord.
Okay, but then but four has said the same thing. 2 has also said the same thing.
Same thing, my lord. But she has seen injury near the ear, my lord. So if I am correct, my lord. And so far as, my lord, that possibly after that injury also she survived, my lord. For
Maybe.
considerable period of time, because he again came, they again had quarrel at 8 p.m, my lord. My lord, my humble submission, my lord, at this juncture, my lord. Can it be, my lord, 304 part 2? Because, my lord, had she been taken to hospital?
304 part 2 on what ground? How do you convert it into a case of
My lord, I understand.
not amounting to murder?
I understand, my lord. Because possibly had she been taken to hospital, in my humble understanding, my lord, and due to hemorrhage she died, my lord. Had she been...
You were the only one who could take her to hospital. You did not.
My lord, but this 2 and 4 also, my lord.
2 and 4 living in a different house.
No, true, my lord. But possibly that injury was not of that such nature, my lord. Possibly, my lord, I do not know. And they did not also feel that she needed some medical aid.
No, it appears that you hit her somewhere in the night, probably.
Probably, that is. But, my lord, there is...
You hit her again in the night after everyone had left.
Because there are 2 occasions, as per the witness, the quarrel took place. Morning.
But that would be, my lord, possibly again. I am with all respect, my lord.
So can it be, my lord, with all respect?
No, you have to tell us a way out, no?
My lord,
You cannot give us the problem
my lord,
and expect us to solve it.
my lord,
You have got to find out a way.
my lord.
You have to stand on your own legs.
My lord, I understand. My lord.
Ah.
But regarding the assault part, my lord, prosecution also, although there is provision of 106, my lord, with all respect.
Correct.
My lord, 106 also does not, my lord, dilute their
Does
duty of
not,
prosecution. my lord.
does not, correct.
The
But then that foundational fact is there under that PW1,
PW1, he has say, my lord, that informant. Now,
extrajudicial confession is there.
Extrajudicial confession is to the extent of, my lord, with all respect, my lord, to the extent of receiving injury near the ear,
So,
my lord, that injury, and at that point of time also she was surviving, my lord. And even subsequent year to also, in my,
tell me something. When
My-
you hit somebody,
my lord,
supposing a person dies
My-
from being hit,
my lord.
is it normal that as soon as you hit someone, he dies?
No, my lord, I understand.
Sometime,
I
no?
understand because
Past sometime, unless you shoot them in the head with a
My-
pistol or something like that, it
Because-
takes some time to die.
past incident 4 p.m., my lord, as per evidence.
Huh?
Past incident of quarrel, my lord, 4 p.m., my lord.
Correct?
And second incident, my lord, allegedly it is 8, my lord. So in between, my lord, 4 hours gap, my lord. 4 hours gap, my lord.
The others have come also to your house.
My lord. They left.
They left. And when did they leave?
My lord, I understand. And no, what I am saying, my lord, that time gap, that had she received proper medication, my lord, with all respect, my lord, she would have survived, my lord. That is my humble submission.
So, so what?
Considering that aspect,
No,
my lord,
we accept that. We
My-
accept that.
my-
But then the thing is that, okay, who is to take her to the hospital? It was you.
She was inside.
It was inside your house.
my lord.
You hit her. Now you're saying if she was taken to hospital, she could have survived.
True, my lord.
You should have taken her then. You
True,
did not.
true, my lord. Because
So
my
if a person is dying and you do not take that person to the hospital for getting a chance to survive,
my
what does that make you? A person who aided in the death of that person.
my
You're shooting yourself in your foot
my
with that submission.
possibly, my lord, if not part 2, my lord, part 1.
How, Mr. Counsel? You see, you have to show that the exceptions
My
to section 300 are attacked.
my
Unless you can show that,
my
then only we can bring the case to a
lesser degree, my
culpable homicide not amounting to murder,
my
in which case 304 can be applied.
my
But you have got to take it out from the 302 by applying the exceptions under 300.
my because of this time gap and her survival, my lord, because time of death, my lord, because 4 p.m. to 8 p.m. she was alive, right? Is apparently. And she died because of hemorrhage, because of the pressure created on her head from the clothing, my lord, in my humble understanding, my lord, if I am not wrong, my lord.
Lordship, there is injury number 3. This injury number 3, contusion in the middle of the chest. So and so on dissection, blood was found collected under the skin. The sternum was fractured. Sternum is this portion, this bone. That means that fracture was caused in the later stage, because had it been fractured in the 4 p.m., it could not have come out. My lord.
But my,
You drink, you both of you drink.
my lord, as per evidence, my lord, both drank that night. my lord.
But postmortem
Possibly,
report, there is no residue of alcohol. Details, stomach.
this, my lord, texture of this portion, my lord, that possibly comes for my rescue because he took the defense that she fell down and sustained. My lord, she died. Because in C13, my lord, he has stated, my lord,
But to fracture this portion,
my lord,
it must have been a deadly blow. It's very, this tough, let me tell you.
I understand.
One of the toughest areas
My lord.
of a human body.
But no recovery of any weapon in this case. My lord.
Because you threw it away.
If he is drunk, my lord, with that, my lord, calculative for planning, my lord, if he is really drunk, my lord, on that day, my lord, that sort of planning, my lord, possibly not possible. And he in the morning itself, my lord,
But you cannot take the defense of being drunk.
that.
I think section 86.
Unless and until it was against my will, my lord. That is true, my lord. Intoxicated mood, my lord, some quarrel, my lord, possibly in the melee, my lord, while pushing and all these things, that I visualize, of course, my lord.
Lordship, if the deceased has fallen from the bed, dear Lordship, after fallen down, after consuming liquor, there will not be any injury on both the sides at page 45. Contusion on right cheek, then contusion on left cheek, contusion in the middle of the chest in size, page 45, Lordship, may kindly have a look.
45.
Yes, my lord. Wound's position and character. Right cheek, left cheek, middle of the chest. Then contusion of scalp is present in left temporal region. Then contusion on occipital region.
Amit Murad.
Murad.
Tell me what? He's a
Tea tribe, my lord. Working in the tea gardens, my tea gardens. Requisite possibly mens rea was not there, my lord, in my humble submission, my lord. The requisite mens rea to finish her off, my lord.
when you see the injuries,
My lord.
you are basically bludgeoning her to death.
Because IO has specifically said that he did not seize anything.
So, as a woman,
True.
I can understand man to man.
Man.
Woman at the weaker sex, you are bludgeoning her so badly.
But all injuries are with blunt object, my lord. As
That is the worst. That's the worst thing. Yeah, hitting with a blunt object.
No,
Can you imagine the pain?
That commensurate with falling part also. My lord. That commensurate.
How much she? So many injuries. So she fell.
No,
and then she rolled.
Yes.
She injured herself. Then she rolled again. Then she injured herself here again. So that rolling also injured her.
No. So, my lord, those part of the life, my lord. Those.
How do you explain? How do you explain the injury on her right cheek, then the left cheek, then in the chest, then in the skull? Not possible.
Lordship, page 11, evidence of PW2. Third line, second paragraph. incident at 4, so on the date of incident at 4 p.m., a quarrel took place in between the accused and his wife, Meena. Thereafter, Meena Mura came to our house and she had shown us injury on her face. And she also told us that she was assaulted by the accused. So it was a continuing offense, Your Lordship. However, we somehow pacified her, and myself and my wife escorted Meena to her house. Thereafter, in the night at about 8 p.m., we again heard the sounds of quarrel between them. Since it was night, we did not come out of the house. So, Lordship, it was going on.
There's nothing quite clear.
Mansria part, my lord, if I can say my Mansria part, because in the next morning he went to their house and told that my lord, his wife is not waking up.
He must have, must have been slightly freshened up a little bit.
Maybe my lord, maybe my lord. But possibly Mansria is not there because from 4 to 8, my lord, if had there been any Mansria to finish her off, my lord, with all respect, my lord, subject to
Look, it's like this. Supposing you hit a person with a blunt weapon once, and you hit a person 5 times, it's a difference. There's a big difference. One time you hit there, you can say that maybe there is no Mansria. But when you continue hitting for 5 times, and especially when you see the injuries,
from 4 to 8, my lord, and had there been any Mansria, my lord, she would have finished off at 4 p.m. in my humble understanding, my lord.
no, not necessary.
My lord. Not necessary. So requisite
PW also repeats the same, madam. Same statement, same evidence.
husband and wife there.
The husband and wife.
The husband and wife.
4 are husband.
Yes.
One is the informant.
Yes, my lord. He is the owner of that garden, my owner of the.
We have not been able to make out 304. We are waiting for you to make out 304. You have not been able to make out.
Well, the evidence is such that
you have got to go by the law, na?
My lord.
What does the exceptions? What do the exceptions to section
My
say?
My lord.
You have to bring the case under one of those 5 exceptions.
My lord. True, my lord.
Then only can this 302 be taken out of context. Out of the case. That's all. There's nothing. Okay, Mr.
NJ Das, my.
NJ Das.
Well.
Learned American School of the appellate. After her, Ms. B. Buyat, learned APP for the state. Assisted by Ms. Agar. The appellant has put to challenge the judgment, impugned judgment dated 8/6/2020, passed by the learned session judge FTC-1, bracket close, Margarita, Tinsukia, in sessions case number 83, bracket M, /16, by which the appellant has been convicted under section 302 IPC of killing his wife and sentenced to undergo
for life.
Rigorous imprisonment for life with a fine of rupees 10,000, in default, simple imprisonment for another 6 months. The prosecution case in brief is that the informant bracket PW1 submitted an FIR dated 22/10/2015 to the officer in charge of the Penjiri Police Station, PNGERE, stating that The appellant who resides at his Biju Liban Tea Garden line started beating his wife since 4 p.m. He further learned from his neighbors as well as the appellant that the deceased had been assaulted till 10 p.m. On going to the house of the deceased in the morning, he found her. Pursuant to the FIR, Pengari, not Pengari, P-N-G-A-R-E, PS case number 87/2015 under section 302 IPC was registered. The investigating officer, after completing the investigation, submitted his charge sheet on finding a prima facie case under section 302 IPC. The two students are getting separately, no? Oh. Then doesn't fit somewhere. Yes, you two at the back who are standing, why don't you sit? You've noticed them standing for a long time. Yes, where are we? On finding a prima facie case under section 302 IPC against the appellant. The learned trial court thereafter framed charge under section 302 against the appellant, to which he pleaded not guilty and claimed to be tried. The learned trial court thereafter examined 6 prosecution witnesses. The appellant was also examined under section 313 CRPC. And the learned trial court thereafter came to a finding that the appellant had killed his wife. Accordingly, the appellant was convicted and sentenced to life imprisonment, rigorous life imprisonment, with a fine of rupees 10,000 from a Hindi form. The learned counsel for the appellant submits that, yes, what is their submission?
Requisite mainstay is not there, well.
That means that there is no proof that there was any mens rea on the part of the appellant in the act of killing his wife.
Right.
As such, the charge under section 302 IPC should be altered to section 304 part 2. 304 part 1 or part 2 IPC.
Right.
But part 1 is intention.
Knowledge and intention.
That weapon of offense not found, my lord,
Okay,
during
next,
investigation.
The learned
And she survived for 4 hours, my lord, or even more. from the first incident, my lord. That can also be.
That is not disputed. He came to the,
To PW,
no weapons is enough.
my lord.
Any other point? The learned counsel for the appellant further submit that no weapon was recovered from the appellant to prove that the appellant had caused the death of his wife. Then what else?
That survival part of our, my lord. That 4 to 8, my lord, or even after death also, my lord.
How?
Because, my lord, had there been intention, my lord, to kill, she would not have survived
It submits.
that
It
period.
submits that the victim, the deceased, had apparently gone to the house PW 2 and 4,
Mine.
who were a couple, at around 4 p.m.
Mine.
after being assaulted by her husband, the appellant. If there was any intention on the part of the appellant to kill his wife, there was no, the appellant, the deceased would not have been able to go to the house of the respondent number 2 and 4 at 4 p.m. That's all.
Mine.
Yes, Miss B. Puyat, the learned APP. That's it. The injuries on the victim show that there was an intention on the part of the deceased to kill. Part of the appellant to kill the deceased.
The relationship was not good. They used to quarrel with each other.
Husband and wife, they always.
They quarrel, but it went to the extent, lordship, looking into the injuries, your lordship.
No, they don't quarrel that way every day. That is only that day. How do you know how they quarrel earlier day?
There is,
They must have been,
there is evidence, my lord, they used to quarrel often, man. Nothing evidence.
but not in this manner.
Possibly, man. Possibly.
Okay.
And
So it
PM
will be-
report reveals, my lord.
Okay, right.
PM report also reveals.
The learned APP submit that the deceased had died in
Instantaneous. Oh,
in
Not-
her own house
yes.
during the presence of the appellant only. As such, the circumstantial evidence proved that the appellant had caused the death of his wife. Further, the evidence of PW1 shows that the appellant had confessed before him that he killed the deceased. Also, the evidence of PW2 and 4 shows that there was a continuing offense committed by the appellant, which eventually led to the death of him. The evidence, further, the evidence of PW2 and 4 also shows that the deceased had informed them at around 4 p.m. that the appellant had assaulted her. Keeping the above in view and the fact that the PW2 and 4 had heard the I had heard sounds of quarrel between the appellant and the deceased at around 8 p.m. which was followed by the discovery of the death of the deceased the next morning. Proved that the appellant was the only person who could have killed the deceased.
An explanation given in 313 doesn't tally with the PM report because injury on both the cheeks and all, but whatever he'd explained in 313. She had
Page.
313 page 21 is the answer, Your Lordship. I did not kill her. She fell down after consuming alcohol.
So further explanation given by the appellant under section 313 CRP that the appellant that the injury sustained by the appellant by the deceased was due to her fall after consuming alcohol. Is not in tandem with the medical report which shows multiple injuries on different parts of the body of the deceased. The learned counsel submit. The learned APP submit that in view of the extrajudicial confession made to the appellant number 1 and the evidence of PW shows that circumstantial evidence pointed only to the appellant being the person who could have killed the deceased and no one else could have been involved in the said act. As such, the appeal should be dismissed. We have heard the learned counsel for the party. The evidence of PW1, the informant, is to the effect that on asking the appellant as to how his wife had died, the appellant had told him that he had assaulted his wife like a deceased with his own hands. So thereafter, PW1 informed the police, due to which inquest report was prepared. So this is the reason why no weapon. He used his own hand.
Breaking the skull, my lord, with hand.
Must
I'm
have
breaking deep with this bone.
caught hold of her neck and pushed her head against the wall.
Maybe, my lord, I don't know.
Could be.
My,
You are the best person to explain.
my lord, I explained, my lord, she fell down after consuming.
So because if she injured this part of her head,
My lord.
she must have somersaulted intentionally and landed on this part.
My lord, if she had, my lord, dashed the wall and thereafter fell and cheek and all these things broken, my lord, that is another possibility, remote, my lord.
How do you fall and dash your head here?
My lord, in the wall, my lord.
Then you would not have fallen. You are in the process of falling.
My lord, if she was drunk, my lord, she was drunk.
So,
My lord, losing her balance.
She hit her head then this part got damaged,
If she
and she
fall down-
rolled some more, then this part got damaged.
My lord,
She rolled some more, then this part got damaged.
well,
Not
those
possible.
those part of village part, my lord, those are not even surfaces also, my lord, to my
And
understanding.
they are not concrete houses also.
Well, those are concrete because it was made a barrack, my lord,
Okay, anyway.
built by the
Right.
garden owner.
Oh. Okay, right. The evidence of PW2, who is a neighbor of the appellant, is to the effect that they, no, who, not who is a neighbor, who resided in the same barrack provided by the owner of the garden,
Leaving one room from the house of the appellant, my lord, because those are line, my lord, quarters. So the next room was vacant. Second next room, somebody else resided. The next room, PW2. my- In between the appellant and the PW2, there are two rooms, another two rooms. So far as the sketch map is concerned.
The evidence of PW2, who is a neighbor, let's say, who is a neighbor of neighbor of the appellant, is to the effect that on the date of the incident at about 4 p.m., a quarrel took place between the appellant and his wife. So thereafter,
Case 50 sketch.
the appellant's wife came to the house of PW2 and showed her the injury on her face and told them that she had been assaulted by the appellant. After PW2 pacified the appellant's wife, the appellant's wife was escorted back to her house. However, at about 8 p.m. in the night, PW heard the sounds of the quarrel between the appellant and his wife. Since it was night, the PW2 did not come out of the house. In the morning, the appellant came to the house of PW2, heavily drunk. And told him that his wife could not wake up. He accordingly asked PW2 to send his wife to wake up the deceased. On going to the house of the appellant, the deceased was found already dead, due to which the matter was informed to the owner of the garden. On being asked by the owner of the garden as to what had happened, the appellant stated that he was heavily drunk the previous night and he did not know when and how he had assaulted the deceased. PW2 further stated that he noticed mark of injury above the ear on the head of the next paragraph. The evidence of PW3, who is the senior medical and health officer of Tinsukia Civil Hospital, is to the effect that he performed the post-mortem examination on the deceased at about 2:30 p.m. on 22/10/2000. The report on the external appearance and opinion of PW is reproduced here in below as follows. Page 13 and till page 14. Next, the evidence of PW4, who is the wife of PW2, is to the effect that she knew the deceased and the appellant. At about 4 p.m. on Durga Puja day, there was a quarrel between the appellant and the deceased. On going to their house, PW4 pacified the appellant and the deceased. Then again in the evening at about 6 p.m., a quarrel took place, during which the appellant assaulted the deceased, due to which he sustained injury on her ear. So the further blood was also coming. After the quarrel, the deceased came to the house of PW4. However, PW4 told the deceased to go to her house, take food and to sleep, which the appellant did. No, which the deceased did. The next morning, the appellant came to their house and told them that the deceased was sleeping and asked PW4 to give water to the deceased. On going to their house, PW4 found that the deceased was already dead. Accordingly, the matter was informed to the owner of the garden. PW4 further stated that the appellant and the deceased used to quarrel frequently. The evidence of PW5, who is the Gaon Bura, is basically hearsay evidence. No, it is basically to the effect that the owner of the garden had called him over telephone and told him that some incident had occurred in the labor's quarter. On going to the house, he found that the appellant had been tied up by persons, as he had killed him. He also came to know, and that's all. Next, the evidence of PW6, who is the investigating officer, is to the effect that while working as an OC of Penagari PS on 22/10/2015, the informant submitted an FIR to the effect that the appellant had assaulted his wife, due to which he died. Okay, hearing concluded, judgment is
Obliged. Deeply obliged.
Before this is
Fine.
Yes.
Madam, there is a order, madam, by which your lordship wanted to know the compensation. Which was, madam, the department has, madam, by regulation, has given 4 lakhs. But in other state, I have submitted chart, lordship, where it is founded, madam, Mizoram 10 lakh, then Punjab, madam, 10 lakh, Haryana 10 lakh, Dakshin Haryana 10 lakh, Delhi 7 lakh, Jharkhand 5 lakhs, and so they have required to take a decision on this regard, whether they are enhancing the regulation or not.
My lord, there are 2 difficulties. One, we convened a meeting in terms of your lordship suggestions. And my lord, meeting resulted in this. And my lord, under the Electricity Act, it is the Electricity Regulatory Authority, my lord, who has to take the call. Section 57, my lord. Basically, this compensation is not for, my lord, the death of the person. It is because of the deficient service of the distribution company. My lord. Because when the financial implications are also to be looked into. Point number 1 is relevant, the rest are not directly connected to the issue.
Point number 1.
Yes, sir, the second page of the issue, sir. What has seen, well, agenda and discussion, well, second page. Brief history and present status of compensation rates. The committee noted that the compensation amount has been revised periodically, first in 2008, subsequently in 13, and again in 2019. The 2019 rate, that is 4 lakhs for death due to electrical accident, is the existing rate. It was pointed out that the rate of compensation is fixed solely by AERC, Assam Electricity Regulatory Commission, and the APDCL has no direct role in determining or revising the amount. Therefore, any reassessment of the quantum of compensation must be taken by AERC, which must simultaneously assess the financial implications. But this is something that has come out during the proceedings. But otherwise, their prayer is to make higher amount of compensation. For that, my lord, we basically, it's not that, my lord, we will deny them. They have to, my lord, justify the negligence and the damage, my lord. So the appropriate forum is civil court, my lord. Our payment is, my lord.
Is it disputed that the petitioner died due to the electrical accident?
No, this is not disputed. No.
It's not disputed.
Under our policy, well, our scheme.
So the only issue, so is that, so it is, so when he's eligible to be given compensation,
Yes, ma'am.
the only issue pertains to the
Quantum. Yes, ma'am. Quantum. So our fixed quantum is 4 lakhs. If I may kindly produce section 57 of the Electricity Act. Ma'am. Under this, we have changed the regulations. Ma'am.
Section
57. Standards of performance of license. The appropriate commission may, after consultation with the licensee, that is APDCL here, madam, and persons likely to be affected, specify standards of performance of a licensee or a class of licenses. If a licensee fails to meet the standard specified under subsection 1 without prejudice to any penalty which may be imposed or prosecution be initiated, he shall be liable to pay such compensation to the person affected as may be determined by the appropriate commission. Provided that before determination of the compensation, the concerned licensee shall be given a reasonable opportunity of being heard. So, well, the compensation determined under subsection 2 shall be paid by the concerned licensee within 90 days of such determination. Under this manner, the AERC has framed the regulations that is annexed into the petition manner. That my lord finds at page 49 of the petition manner. This regulation is under attack, my lord, in these proceedings. Page 49, ma'am.
Yes.
In exercise of page 49, this is the regulation AERC, Assam Electricity Regulatory Commission, compensation to victims of electrical accidents regulations 2019. In exercise of powers conferred under 181(1), read with sections 57(2) and 57(3) of the Electricity Act, and all other powers enabling in this behalf that the previous publication, after previous publication, the Assam Electricity Regulatory Commission hereby makes the following regulation. This is the regulation, madam. Here, my lord, you kindly see page 59, my lord, clause 21.
Yes.
It says, my lord, any dispute or difference regarding the entitlement to compensation on death of a human being in an electrical accident or the ownership of an animal involved in an electrical accident or any person aggrieved by the orders of the managing director, chief executive of the licensee granting generating company, CPP concerned on the quantum or entitlement shall be deemed to be a grievance in accordance with the Assam Electricity Regulatory Commission Redressal of Consumer Grievance Regulation 2016. And its subsequent amendments, the disputant shall be entitled to make a complaint before the electricity ombudsman. So if they are agreed, they can go to electricity ombudsman with the quantum. Next, relevant matter, notwithstanding the above, the aggrieved person may approach a civil court. Then, my lord, clause 26, my lord. The provisions of this regulation shall be in addition to and not in derogation of the provisions of any other law or rules or regulations or scheme or contract for the time being in force. Nothing in this regulation shall deem to limit or otherwise affect the inherent power of the commission to make such orders as may be necessary for meeting the aims of justice or to prevent abuse of the process of the commission. Then, my lord, page 68 is the quantum. Page 68, my lord, first is the schedule B. Schedule number 1, compensation payable for loss of human life as a result of an electrical accident is 4 lakhs. So, my lord, my humble submission is that, my lord, it is not the, my lord, damage that is specified.
Schedule B is part of this.
Yes, ma'am. This regulation, ma'am.
Yes, ma'am.
This regulation. This compensation is fixed.
This of this regulation 2019.
My lord. But this compensation is
So
fixed.
this is a statutory
Yes, madam.
regulation.
Made under section 57, madam. And 181 is the rule making power, Electricity Act. So my humble submission, my lord, it is not a, my lord, compensation for the death. It is a penalty imposed to the APDCL for, my lord, meet the standards of my lord, service. Because 57.2 says, if a licensee fails to meet the standards specified under subsection 1 without prejudice to any penalty which may be imposed or prosecution may be initiated, shall be liable to pay such compensation to the person affected as may be determined by the commission. Because, my lord, we fail to meet the, my lord,
57.
standards. That is why this is the compensation. Beyond that, my lord,
57.
my lord,
57.
section 57 of Electricity Act.
Yeah.
Under this, my lord, these regulations were framed. Standards of performance of licensee will be fixed by the commission, my lord, 57.1. 57.2, my lord, if a licensee, that is APDCL, my lord, fails to meet the standards specified under subsection 1, without prejudice to any penalty which may be imposed or prosecution be initiated, shall be liable to pay such compensation to the person affected as may be determined by the commission, appropriate commission. So, my lord, it is the failure of the licensee, my lord, to meet the standards specified. It is not a, my lord, compensation for death. It is the penalty imposed upon the APDCL because we fail to meet the standards. So for compensation, my lord,
You will have to pay this to the authority, AERC.
my lord, we directly pay to the victim, my lord.
To the victim.
To the victim. They say the quantum is less. But in that situation, my lord,
So there has to be a finding that you fail to meet the standard.
yes. There is a finding that, my lord, there was electrocution.
That report from the electricity.
My lord,
Correct.
exactly.
Where, in this case, where is that report?
That report, it's there, my lord.
No, the report, but the report would have to out of the APDCL. Page 22.
The police, it's a report formed by electrical inspector. The police report of an electrical inspector report.
No, this is from the officer charge. This is from the.
Yes.
It cannot be from the police.
It has to be from the electrical inspector.
It has to be
Then
from the
generally in these cases, there is always a report.
Yes.
The
made down to
AERC.
producers.
Then your page 22 is something else.
Report says that how the accident occurred on the.
Yes, the council, you are not, you are not getting we're not on the same page.
Electricity report is not.
You are marching to a different drumbeat.
But we are not disputing that dates, my lord. What I'm on is that to quantify, my lord, probably, my lord, this forum is not the appropriate forum, my lord. They can go to the ERC against that 4 lakhs, my lord, or file a civil suit for.
No, first of all,
My lord.
this 4 lakhs to be given to him.
Yes,
There has to be a report made, correct?
yes.
Report is to be made by whom?
By the chief electrical inspector.
By chief, they're stating that the licensee fails to meet the standards
Yes,
while performing his work.
yes, ma'am. Yes, ma'am.
So where is that report?
That report is not yet, not here annexed, madam.
Well, some finding, it's page 41, Lakshmi, can you see? Before that, they approached the Human Rights Commission, madam. There is some, as, Lakshmi, page 41.
But otherwise, madam, we have paid that 4 lakhs rupees, madam.
You
There is no
have paid it to him.
We have paid that, my lord.
Then
There is no
don't-
dispute to that, my lord. So report has to
My
be
lord,
seen, my lord.
they have paid.
This is different. You cannot challenge it. You cannot challenge this 4 lakh because it's a part of the regulation. Because that limitation is there till 4 lakh only.
Yes. Beyond that, they have to file a suit or.
You challenge the regulation itself.
That's why you challenge the regulation.
You challenge the regulation or no, but what is unconstitutional about?
My lord, my case
Because
is
the
this-
money is less
this-
doesn't mean that it is unconstitutional.
Lakshmi, can you see
That's
the
Let-
finding of the, my lord, the Human Rights Commission, page 41, my lord.
No, Mr. Counselor, how can you challenge the amount is less?
As per the report.
No, some is 10 lakhs, some is 4 lakhs, some like that. No, how can you challenge the regulation? You see, there is nothing. You see, when you challenge a regulation, it has to be on the ground that it is ultra virus the constitution.
Because
So just because some states make it 10 lakhs, some states make it 5, some 4, doesn't mean that just because it is less here, it is 4 along with Bihar, that it becomes ultra virus. Money does not make it ultra virus. It depends upon the paying capacity of the state.
my lord, I have relied on some Supreme Court judgment, my lord, wherein, my lord, the Honorable Supreme Court more than 50 lakh granted, my lord, for the debt of the electricity. Due to elect.
For that is a different issue.
That is, my lord, in exercise of 141, my lord. That was a case.
142.
142, my lord.
That apart, my lord, suppose in a, my lord, the railway claim tribunal, they are giving, my lord, 8 lakhs.
Mr. Counsel, the problem here is there is a regulation made under the Act. It is a statutory regulation. Now, you have got to show that the award of 4 lakh only on the issue of competence of the licensee is illegal. What is wrong? Because that is there, if the limitation is with regard to their competency in or doing a proper work. That's what. Your right to claim 4 lakhs and above is not hampered by this. Go to civil court.
This 4 lakhs amount is my.
99,760.
Inadequate, my lord, because the cost of the human, my lord.
This is the issue is this. You are challenging the regulation. Only on the ground that 4 lakhs is too less. Now, can that be a ground to challenge the regulation? What are the law for which a regulation can be made ultra virus? What is the law?
It should be unconstitutional ultra virus, my lord.
How? How is it unconstitutional?
Because, my lord, life is, my lord, life and liberty, my lord, which is Article 21, my lord.
Is the competency of the authority in making the regulation in question?
No, no.
Then now you see,
So that's
according to you, how much amount would make it constitutional? According to you,
yes, ma'am.
what amount of compensation would make it constitutional?
This, that's why, my lord, this honorable court want to see, my lord.
No, no, that is why we are asking you. You are making a claim. According to you, what would be the amount that would make it constitutional?
Well, at least 10 lakh, my lord.
What is the basis for that?
Well, financial implication on APDCL also is to be taken note of, my lord.
And what about Delhi 7.5 lakhs, Jharkhand 5 lakh, Bangalore 5 lakh, Manipur 5 lakh, Tamil Nadu 5 lakh, Andhra Pradesh 5 lakh, Telangana 5 lakh, Kerala 5 lakh. So all the regulations are also ultra-virus. Why don't you have to make them all parties, by the way, all these states? Because if you say that this is unconstitutional, unless it is 10 lakh, then even theirs become unconstitutional. By the judgment of our judgment, it will ipso facto mean that theirs also become unconstitutional. Make them parties, then we'll decide. Make all the states parties, all these states. You have to make it, you want 10 lakh, there is only 5 lakh.
So for 4 lakhs, my lord. Yes, the last one.
You've got to be reasonable, no? Maybe you file a civil suit.
Well, not with my lord, disputed facts, my lord. Here, my lord, so far the death is, there is no disputed death.
No, but this, you see, this regulation limits the payment to only 4 lakhs. And that also for not doing their work properly.
Well, what authority said, man, my land friend is, initially said he is not authority.
Huh?
To increase regulatory integrity. What is the?
AERC is the authority who can, my lord, reframe these regulations. And my lord, AERC also is the authority to whom, my lord, he can approach again if the amount is less, my lord. Instead of, my lord, challenging the entire regulation, he can make an application to the AERC that is a particular, in this particular case, I should be paid higher. Or civil suit not. Otherwise, on this point, my lord, there are 2 judgments of Supreme Court that it's a tortious liability. It has to be assailed in a suit, my lord. To 1997 7 SCC.
This is a regulation. This is a regulation. You see, you cannot.
Merely because it is unreasonable or less.
From that, the compensation amount is too less.
Lordship may fix it another day, my lord.
No, we are hearing you.
Today, Lordship asks about the, my lord.
Hearing you. We have got it right in front of us. He has explained to us.
No.
He's made it more clear. That's all. We're disposing it off. You can go to Supreme Court and then you can say that 10 lakhs, if it's 10 lakh rupees, then the regulation is the validity of the regulation need not be challenged. How can it do? Everywhere is different. Jharkhand is giving Andhra, Tamil Nadu is giving 5 lakhs.
Just to assist your lordship, my lord, 2 paragraphs of a judgment, exactly identical case, my lord, of the Honorable Supreme Court. 1999 7 SCC 298. Remember. 1999 7 SCC. Okay, 97 98. If I may read slowly, my lord. Paragraph 5 and 6. 1999 7 SCC 298. It says, my lord, the background fact was this, my lord. It was contended by the learned counsel for appellants that it was highly improper
on the part of the High Court to have entertained the writ petitions in view of the specific defenses raised by the appellants, and to arrive at the conclusion of negligence on the basis of the scanty material placed before the High Court by the writ petitioner, and which was not subjected to cross-examination. He submitted that apart from establishing that the death had occurred because of electrocution, it was also required to be established by the writ petitioner claimants under what circumstances electrocution had taken place, and that the death had taken place not because of any negligence of the deceased. He further submitted that it could not be said that in these cases, that the facts as stated by the writ petitioners were disputed by the appellants just for the sake of disputing them, and that there was no substance in the defense raised by on behalf of the appellants. The learned counsel for the respondents, on the other hand, tried to support the judgments of the High Court for the reasons stated therein. In our opinion, paragraph 6 is the finding. In our opinion, the High Court committed an error in entertaining the writ petition, even though they were not fit cases for exercising power under Article 226 of the Constitution. The High Court went wrong in proceeding on the basis that as the death had taken place because of electrocution as a result of the deceased coming into contact with snapped live wire of the electric transmission lines of the appellant, that admittedly prima facie amounted to negligence on the part of the appellant. The High Court failed to appreciate that all these cases were actions in tort and negligence was required to be established firstly by the claimants. The mere fact that the wire of the electric transmission line belonging to appellant 1 had snapped and the deceased had come in contact with it and had died was not by itself sufficient for awarding compensation. It was required to be examined whether the wire had snapped as a result of any negligence of the appellants or under which circumstances the deceased had come in contact with the wire. In view of the specific defenses raised by the appellant, in each of these cases, they deserved an opportunity to prove that proper care and precautions were taken in maintaining the transmission line, and yet the wires had snapped because of the circumstances beyond their control or unauthorized intervention of third parties, or these questions could not have been decided properly on the basis of affidavits only. It is just leaks. Finally, it was
the problem. Out here, the issue of negligence or anything, that is not the issue. The issue is basically with
even for the quantum.
But negligence is there already.
Negligence may be there.
Negligence is there. So the only issue is with
Quantum.
Quantum.
Quantum also has to be quantified. Merely saying that 10 lakh, it may be 20 lakhs also.
No, but then the issue is, what about this regulation provides for only 4 lakhs?
4 lakhs. Rest, my lord, against that 4 lakhs, my lord, they can file an application before AERC. That regulation itself provides for that. If they agree with the amount, my lord, they can.
So, I mean, the issue with the validity of this regulation,
yes,
whereby 4 lakhs have been quantified.
Yes, my lord. Exactly. So, for in that situation, my lord, what will happen, my lord? Merely because something is unreasonable or causes some hardship, my lord, the regulation may not be strike down. My lord. That's the law, my lord. There has to be either in legislative incompetence or violation of fundamental or constitutional rights, my lord. That they have failed, my lord. Their only thing, well, basically compassion, my lord. We do have compassion, my lord, but that cannot be a ground for challenge, my lord.
No, that means that effect.
Yes, paragraph 1996 3 SCC 709.
What is there to decide?
Because today
it
was asked.
Is on a limited question. Only one. If the first question is answered in your favor, then question 2, 3, 4 will come. But if the first question is answered against you, then doesn't matter. There's nothing beyond that.
This amount is unreasonable, madam. By proceed, madam.
94.
Yes, which para?
Paragraph 43, my lord. Page 737, my lord. Sri Rohinton Nariman submitted that inasmuch as a large number of persons falling within the exempted categories are allowed to consume intoxicating liquors in the state of Andhra Pradesh, the total prohibition of manufacturing and production of these liquors is arbitrary, and the amending act is liable to be struck down on the ground alone, this ground alone. Support for this proposition is sought from the judgment of this court in state of Tamil Nadu versus Ananthi Amal. Before, however, we refer to the holding in the said decision, it would be appropriate to remind ourselves of certain basic proposition in this behalf. In the United Kingdom Parliament is supreme. There are no limitations upon the power of Parliament. No court in the United Kingdom can strike down an act made by Parliament or any ground. As against this, the United States of America has a federal constitution where the power of the Congress and the state legislature to make law is limited in two ways. That is, division of legislative powers between the state and the federal government, and the fundamental rights. Bill of Rights incorporated in the Constitution. In India, the position is similar to the United States of America. The power of Parliament, and for that matter, state legislature, is restricted in two ways. A law made by Parliament or legislature can be struck down by courts on two grounds. The two grounds alone, that is, lack of legislative competence and violation of any of the fundamental rights guaranteed in Part 3 of the Constitution or any other constitutional provision. There is no third ground. We do not wish to enter into a discussion of the scopes of procedural unreasonableness and substantive unreasonableness, concept inspired by the decision of the United States Supreme Court. Even in USA, these concepts, and in particular the concept of substantive due process, have proved to be unending controversy. The latest thinking trend towards a severe curtailment of this ground, substantive due process. The main criticism against the ground of substantive due process being that it seeks to set up the courts as arbiters of the wisdom of the legislature in enacting the particular piece of legislation. It is enough for us to say that by whatever name it is characterized, the ground of invalidation must fall within four corners of two grounds mentioned above. In other words, say if an enactment is challenged as violative of Article 14, it can be struck down only if it is found that it is violative of equality clause, equal protection and clause enshrined therein. Similarly, if an enactment is challenged as violation of any of the fundamental rights guaranteed by clauses A to G of Article 19(1), it can be struck down only if it is found not saved by any of the clauses 2 to 6 of the Article 19, and so on. No enactment can be struck down by just saying that it is arbitrary or unreasonable. Some or other constitutional infirmity has to be found before invalidating an act. An enactment cannot be struck down on the ground that the court thinks it's unjustified. Parliament and the legislatures composed as they are of the representatives of the people are supposed to know and be aware of the needs of the people and what is good and bad for them. The court cannot sit in judgment over their wisdom. In this connection, it should be remembered that even in case of administrative action, scope of judicial review is limited to three grounds: unreasonableness, which can more appropriately be called irrational, illegality, and procedural impropriety. So, my lord, besides that, my lord, one point also is to be taken note of. Section 57 also said the financial implication on APDCL is also to be looked into, my lord. Because we may not be able to withstand the weight, my lord, of if the amount is hiked. Even in the case of, my lord, though it was in a different context, Umadevi, it was in paragraph 19, it was held that court should not impose financial burden on the institutions. That it was in the context of giving regulation. But because, my lord, AERC is the best suited for that. If they're agreed, they have two routes, my lord. If they're agreed, they can very well file an application before AERC for higher compensation, or they can file a civil suit, my lord, only because 4 lakhs is less.
But supposing they file a civil suit, won't that limit of 4 lakhs again be a roadblock for the?
No, my lord, because our regulation itself says they can file a civil suit, my lord. If my lord peruses the regulation, my lord, page will be, my lord. Regulation starts at page 59. More questions. Page 59, my lord, clause 21. Any dispute or difference regarding the entitlement to compensation on death of a human being in an electrical accident or ownership of an animal involved in an electrical accident, or any person aggrieved by the orders of the managing director, chief executive of the licensee, generating company, CPP concerned on the quantum or entitlement shall be deemed to be a grievance in accordance with the Assam Electricity Regulatory Commission Redressal of Consumer Grievances Regulations 2016. and its subsequent amendments. This disputant shall be entitled to make a complaint before the electricity ombudsman. Secondly, my lord, notwithstanding the above, the aggrieved person may approach a civil court. So we have bound ourselves, my lord, that we have assured ourselves from, my lord, saying that you cannot file a civil suit by this regulation. No? Merely because it is not, my lord, suitable for petitioner, my lord. Regulation cannot be stand down.
Page 59.
This one, I have seen, madam, this is.
But one.
Right. Madam, one thing, madam, I have to clarify, though they said, madam, paid 4 lakhs, but earlier 3 lakh paid. And in their affidavit, though stated 1 lakh will be paid. They have not paid.
If we have not paid, we will place off. What question? No, hold on. Okay, Assam, it will- Then it was your amount with my- What was it? Yes, it was- Okay, comply with this.
Heard, Mr.
Jivdul.
Another something for the petitioners. Petitioners,
Yes, sir. 4 petitioners.
why 4?
4 persons.
4% died in the same incident.
4 persons died in the same incident. How did they die?
Madam,
Electrocution, ma'am.
due to electrocution, madam, the snapping of the wire.
Also heard Mr.
The children there.
Huh?
I'm appearing for APDCL, ma'am.
For the APTC. And Mr. Number 3, bracket AER. Yes, sir? Yes, sir.
Yes, mentioned application number 2201. The order has been written.
There was a challenge to the earlier regulation that was dismissed, ma'am. Identical challenge was made by
16 regulation.
earlier was 17, ma'am.
17.
That was unsuccessful challenge in this form. Ma'am.
Which portion?
It's Rabri.
For which portion of the regulation was
That same, ma'am, quantum.
same?
Same quantum.
4 lakh.
You
Yes.
have a copy of that judgment?
Yes, ma'am. Yes, ma'am.
Give a copy.
4201.
Supreme Court. Civil Court.
Yes, that's the direction is given, madam. Yes, land a single judge, madam. That was before land a single judge.
Oh, simple.
No, no.
This office memorandum 25,970 is a different. It's an office memorandum, not the regulation.
Yes, ma'am.
It was OM, my lord.
OM is different. Okay. Third, Mr. You did, I'll be second. That's possible. This petition dismissed. We'll pass the order.
Madam, so far payment, my lord, there is many payments.
Payment will be pay in case that 4 lakhs is not paid. The balance amount should be paid.
Well, difficulty is there. We have paid 3 lakhs, I suppose, my lord. And my lord, death occurred, my lord, in the year, my lord, 2016.
So
Then the 17 regulation,
you verify and pay.
whatever was the amount on that date, my lord.
Verify and pay the amount. Verify it
My lord.
within a month.
My lord.
Liberty may be given now to us.
That there is no bar.
Some limitation, question of limitation is also there.
No, section 14 is there.
No, well, so far civil.
Section 14 is there of the Limitation Act.
Obligement.
Okay.
Your lordship. The convenience compilation has been filed as per the last order. Because these matters have been taken up by the regular DP1. Lordship, have this compilations?
Please let all these matters be listed for final.
Prior to that, there was an order.
Uh,
Prior to that, convenience compilations.
Compilation volume has been filed today.
Yes. There was an order when your lordship was, what am I?
Tile binding.
Spellmaning. But the thing is that before we, lordship is there, because in these 3 matters, I will be taking considerable time. And your lordship, as I have been notified that my lords will be taking up only today only.
Today and Friday.
Today and Friday. So if your lordship will keep it parted, then I can commence. Because otherwise it will be futile exercise. Because the issue is that my lord has already heard this matter once with the Honorable Chief Justice. This matter. The interplay of the 6th schedule with the plenary power of legislation. And there was a division bench judgment which says that you can't do it. Appeal in the Supreme Court. Only word is that whether the word transfer, whether the allotment, setting apart includes settlement. That is the thing. And which I respectfully find that I'm doing thing the settlement is giving lease. Assam settlement rules, and that power does not have. So it will take a period of time. So your lordship wants to get, I can comment, but your lordship will have to continue on Friday.
No problem.
My lord. The lordship will kindly come to the convenience company.
Yes, but Mr. Prepare.
And the petitioner challenged the legislative competence of the Autonomous Council to enact the law. Our law is the Karbi Anglong Land Revenue Act 1953. We have enacted under paragraph 3 of the 6th schedule to the Constitution of India. And the Supreme Court referred the case regarding the transfer of land, that case. At that time, we don't have the power regarding enactment of law on transfer of land. In 1995, alienation of land was inserted in the Constitution, empowering the Autonomous Council to make law on alienation of the land or transfer of the land. In this particular case, while validity of the Karbi Anglong Land Revenue Act 1953 was challenged on the ground that Autonomous Council does not have the power. My lord, I will refer 2, 3 cases, my lord. I'll not
How
take
will you
for that,
take?
my lord. 2 days.
How long will you take?
I will take half an hour. That's it.
Your issue is very small, I think.
My lord, my lord. No, my lord, I can distinguish it, my lord.
What
What is the
my
case law?
what my learned friend is referring.
We are relying on the same case, my lord.
What my learned friend is referring is that learned friend is saying that Karbi Anglong Land Revenue Amendment Act was enacted in 1953. Subsequently, in the year 1995, constitutional amendment was brought in, which para 3A was being inserted. In para 3A, alienation of land was being included. That's, I agree. But as far as alienation of land is concerned, there you will bring, your lordship will appreciate, it will transfer plus lease will come into play. Till date, the Karbi Anglong government has not enacted the law under exercising the power under 3A. Roman A, that is after 1995. They have brought it under 1953, under exercising the power under 31A, where this power is not there. That is my case. The lordship will kindly come to the order, kindly come to the convenience compilation, page 2.
No, only one might take some time. Mr. Chutti, I think though I remember a little bit of this case.
Yes, my lord.
No, the point also is not very big. Problem is that we have got some judgments which we have got to pass today. We have given the decision, but the dictation has to be given also. So there's slightly hard pressed for time.
But I would have loved to argue before your lordship because the order was of your lordship 24/7. I would have cleared anyway, your lordship. I will leave it to you, my lords. My lord, in that case, can your lordship may fix on the third,
11.
any hearing there on March 10th? 10th of March?
Why so far away?
My lord, your lordship, February already in DB1 certain matters have been fixed and I won't be available after 18th, my lord. So 10th of March, because both of us will be able to argue.
10th of March.
10th of March.
Right, on the prayer, the matter on.
Oblige, your lord.
Matter may be taken after some time or another day. As the conducting council, he got a call from lower court, so.
So, lower court.
Yeah.
District court is no.
District. No.
Okay, right. Yes, on the prayer for adjournment made on behalf of the appearance council. This the matter.
2 weeks.
After 2 weeks. There is an extrajudicial conviction also. B2C.
Yes, lordship.
It's a matter which have we heard
On last date, Lordship, he argued his part.
I was taking a lordship to the judgments.
Did I make any note?
Ah. I had taken my lords through the facts of the case, including the evidence, the FIR.
Most probably all forgotten. No, this last week.
Last week, my lord, last Wednesday.
Didn't I make any notes?
My lord was making some notes, if I may recollect properly.
Okay, something in the train.
Yes, my lord.
Yes. When is the thing? Okay, this is the one, no? This is- Notebook of changes. Yes.
My lord, will hear the matter today.
We've got a slight dilemma. Uh, how long will you take?
My lords, I had taken my lords to the judgments. I just, in fact, on the last occasion, I just taken my lords to one judgment. There are a couple of more judgments that I need to take my lords through.
You have submitted a big bunch of.
I know. No, the problem is.
You have not done.
I have not.
It is there, my lord. Everything is there in the criminal appeal.
That will not require from me.
The thing is that we have, if we decide this matter, we have got to pass a judgment very fast. Because my brother might be having some problem till the 12th. So we do not know if we can complete it by 12th. I won't be here next week. And again on Friday, we are having DB1.
Yes.
My lords, can we try our luck on Saturday? Huh?
He's not going to be here.
It will take some time, my lord. So I will also cite some.
The problem is that you'll come at the last all the time.
My lord, because one IA is pending, that is the reason why this is happening.
Actually, what has happened, my lord, my learned friend's client got bail, suspended, sentence. Another case regarding my learned friend, his IA is pending. That's
Since
why.
that is filed in 2025, that is why it's coming on the
last of the cause list. Otherwise, it's a 23 matter, my lord. So it should have gone higher up the cause list. But since this I is pending, so this is always coming in the later part.
Either we can dismiss the IA.
My lords, that will be a prudent.
Lordship can, yes, Lordship,
That
my
will be a
I may be
prudent thing to do.
dismissed. Then,
Yes.
Then it
that
will
will-
come up, because
come up
otherwise,
higher up.
you see,
Yes.
today what has happened is, some judgments have been kept pending.
Yes, Lord.
Decision made, but order still to be pronounced in the court. Now the time is required. So my brother is going to require time for that.
So Lordship, my I may be dismissed, today.
Then it will come in top of the list, but otherwise,
Yes.
because of his IA, my lord.
It's always coming in the last item.
I'm always noticing, always it comes with.
Yes.
Last
Yes,
item.
since May to 25.
And another thing is, don't make it too long. Yeah, if you give too many judgments.
No, my lord. I'll not make it a jaundiced idea.
You see, you lose the attention of the court.
My lord.
Lordship, in if matter is heard today, I will take 10 to 15 minutes for all this case from my part, 10 to 15 minutes. And all are in bullet points from my side.
Judgment.
Yeah, we'll dismiss the IA, then we
Yes,
can hear
Lordship.
it better. Otherwise, every time it comes at the last. Which IA is this?
I.
555.
555, 25.
Heard Mr.
M. Pathak.
M. Pathak, learned counsel for the applicants. Also heard Mr. R. Kaushik, learned additional PC. Then you take this order dated 5/8/25. Para 2, para 3, para 4, para 4, para 5. This has been rejected by Justice Surana.
Yes, Lordship. Honorable Justice Surana and Honorable Justice M. Kolita, M.K. Kolita.
Then it has to go before them. Did we reject it? No. It has been rejected. They had filed an application for suspension
Yes.
before that court.
My earlier bail was rejected by that bench.
Whether it is applicable in case of
My lord,
suspension.
it's suspension sentence. These are exactly bail. In fact, on
It will be and bail. That suspension will be automatically covering bail also, I think, na?
on the last occasion, my lord, if the other case that I was arguing on, there my lord I was going to my lord's judgment and my lord has defined what is the suspension sentence and what is bail. There's differentiation between 389 and 439. My lord, now right now I don't have with me.
My lord,
Just show me that order. Well, we don't.
and regarding my lord, this listing of matters regarding earlier rejection, there was some notification. There this suspension is mentioned, not there.
No, but then he's saying that some order has been passed.
Yes, my lord. My lord had passed the order. Unfortunately, I do not have the file with me right now.
Well, he said
Some other-
it had been distinguished. Suspension of sentence and
And bail.
had been distinguished.
Yes, my lord.
So if it had been distinguished, it notifies the step we are going to take. And that's for the simple reason.
Do you have a copy of that notification?
Sorry, but I don't have that. I think it was 27 of
Yeah, right.
5 or something. 17 of 25 or 20.
Para 5 was 30. Huh? You give us that. You give me that when? Tomorrow.
Tomorrow, my lord.
On considering the fact that the matter has been the matter is in the hearing stage. Because of why does it come at the last?
Newly filed.
I is 25, my lord, filed in 25.
Oh, that.
PSIA was disposed earlier.
23.
23.
Then my client went to the Supreme Court, got the bail, and on the ground of parity, they applied for a bail.
But there is a case, there is a judgment on parity, Supreme Court.
Yes, my lord, but then why the reason I was granted bail was the long pendency, the time that is being taken by the high courts for disposing of criminal appeals. Now that will not be applicable. Because my lords are ready to hear the matter.
Okay, after this para 5, you say. Now, Mr. M. Pathak, learned counsel for the applicants, submit that this bench can dispose of the matter on merit as the matter pertains to suspension of sentence and not with regard to. No, matter basically is with regard to suspension of sentence. Good stuff. In the case of, we just take this parasa. Just take this out. This one para. On considering the fact that the present application is basic. An application for suspension of sentence for which a natural consequence may be an order for enlargement or bail. This matter, this issue, the present application can be disposed of by us. Correct. Next. On considering the fact that the matter is already ready for hearing and has also been heard at some length. The prayer for suspension, for grant of parity, for grant of the benefit of parity for suspension of sentence insofar as it relates to the applicant hearing. Does not arise. Is no longer an issue, can no longer be an issue in the present case. According, the application is rejected. I is accordingly disposed of. Rejected. And then we write in the main case. On the prayer of the parties, list the matter on. Next week, I'm not there.
On 7th of February, if possible, Lordship.
7, my lord is not there.
Okay.
My lord is not there. My lord on 17th.
17th.
17th of February.
Okay. 18. 18.
18, my lord, can be 19th. 18, my lord, is also fixed another matter on the service tax issue.
19. Service tax.
Yes, my lord.
On 19 Lordship, it is just first top of the hearing column, Lordship.
19th.
19 February.
You will mention it. Oh. As first item in the hearing.
Yes, Lordship, yes. Obliged, highly obliged, Lordship.
So hopefully we can dispose it of then.
Yes, Lord.
Yes, Raja.
Obliged, my lord.
Obliged.